ready.
May it please the Court, my name is Barbara Wagner and of the firm Wagenheim & Wagner in Fort Lauderdale, and with my co-counsel Mark Zients, we represent Robert Ben Jr., the appellant in this appeal. At this time, I'd like to reserve 8 minutes of my time for rebuttal by Mr. Zients. This is an appeal, Your Honors, from an order of the Judge of Compensation Claims back in December of 2009, denying benefits to Robert Ben Jr. by declaring a workers' compensation policy void ab initio based on a finding of misrepresentations by the employer and finding alternatively that the claimant was not an employee of the insured business. Because the judge lacked authority to impose this remedy, because he failed to follow the statute as well as clear precedent from this Court which governs the circumstances of this case, and because he made findings which are totally unsupported by the evidence, we request respectfully that this Court reverse the order denying coverage and benefits and remand to the Judge of Compensation Claims for reinstatement of those claims. Mr. Ben sustained catastrophic injuries, including burns over 80% of his body and amputation of his dominant left hand in a motor vehicle accident on January 15, 2008, while admittedly in the course and scope of employment. At that time, he was working for Shamrock Services. He was 32 years old and had been working full-time as a painter for almost a year at that time of that accident.
Are Shamrock Services a legal entity?
The insured is Amar Prakash, a gentleman doing business as Shamrock Services. It is not a corporation. It was, I guess, could be considered a sole proprietorship. It was a gentleman who offered various, a jack of all trades, so to speak, offered various maintenance services to various customers and hired employees to do those services.
So is it a registered fictitious name or not?
It was not at all at that time. Much later, after this accident and after obviously some of the ramifications became known to him, there were corporate filings made, and I believe he incorporated a business, but none of this took place. At the time of this accident, the sole entity for whom Mr. Bend worked was Shamrock Services.
And there was a single tax ID number?
Absolutely. Everything was single with regard to Shamrock Services. It was one set of books. It was one insurance policy. It was one set of advertisements. In any of the contracts that Mr. Prakash had with the various customers that he had, it indicated that this is a business doing, and he listed all of the various services that Shamrock Services did. That was included lawn maintenance, but it also included pressure cleaning, parking lot sweeping. He put an ad in a newspaper.
All that goes to your second issue about whether
there was a separate
multiple employers.
Correct.
And so we still have to get over the first hurdle that JCC set, which was whether the policy was in existence as to any of these employers, correct?
Right. And, Your Honor, it's our position that there should absolutely not be a remedy such as was imposed in this case with regard to a workers' compensation policy. Workers' compensation is unique social legislation. It's mandatory insurance. It's designed to protect injured workers. It's unlike the cases cited by appellees, such as life insurance policies, where perhaps someone makes a misrepresentation with the idea that someone can collect based on a misrepresentation that was made at the time of a policy. In workers' compensation, it's not only a contract between the insured and the carrier, but it's for the benefit then of all the employees of that business.
Do we even have to reach that issue if we determine that whether or not these policies can be voided like other insurance policies, it's got to be done by a court rather than a JCC?
Your Honor, you need to reach the issue of whether it can be done at all. And I think because it was done by a JCC in this case, we absolutely have to determine that it was wrongfully done, because this type of precedent would create chaos in the world of workers' compensation, so to speak.
So are you conceding that if it can be done, a JCC can do it?
No. No, Your Honor. A JCC only has the authority imposed by the statute, and there is absolutely nothing in the statute which allows a JCC to void an insurance policy or reach an issue like this, which not only impacts the case before him and the particular claimant before him, but every employee that would have worked for that company as of that time or any time before it that might have a claim. And as has been pointed out in the briefs, it's not just academic in this case, because there was another employee in the vehicle with Mr. Bend. So
I'd like to
here's
understand your position a little bit, though. In terms of the circuit court's authority, are you suggesting that a circuit court may have the ability to void other types of insurance policies, but because workers' compensation is special in its nature, that it wouldn't even be proper for a circuit court to do that?
Exactly, Your Honor. That's exactly what our position is that even if this were in circuit court, the same authorities would have had to been relied upon, which primarily is the Perkins case as well as the workers' comp statute, which is a whole lengthy statute that deals with all the particular nuances of workers' compensation law, which is different than just general insurance and is not governed by the insurance code. In the recent Supreme Court case in Bifulco, it was noted that if another portion of the statutes anywhere is to be included or considered in terms of a workers' comp case, it would be specifically mentioned in the workers' comp statute, and it is not in this case.
What is the specific language in Chapter 440 that cannot be reconciled with 642.409?
Well, it's the language in 440.381 that does provide the remedy when there are misrepresentations with regard to an application for insurance. And I know that the carrier has attempted to, I would like to say, split hairs by, and the JCC as well, by saying that that's only premium avoidance. But number one, it doesn't say that in the Perkins case, which interpreted that section. And secondly, anytime a application for insurance is made and a classification of business is given, there can be no other reason. You're applying for a workers' compensation policy, and the classification, it indicates right in the application, is what determines the premium.
But you're not saying there's language in 440.381 that says 642.409 shall not apply.
It doesn't say that explicitly, but because 44381 addresses the same type of remedy that 627.409 purports to address, the specific statute that is included in the workers' comp law is what needs to govern workers' comp. And in addition, you have to look at the nature of the type of insurance that it is that it covers a whole period of time and a lot of employees. And to be able to go back and say that a policy never existed from the beginning is just not a realistic or appropriate remedy in terms of workers' comp.
So you're, excuse me.
Well, in addition to that remedy, 440.381 also includes a provision which requires the employer to indemnify the insurer if it fails to report employees on a particular report. So would that suggest to you that those are the exclusive remedies, the penalty provision and the indemnification in the context of workers' comp policy? Absolutely.
There are lots of exclusive remedies granted in the context of the workers' compensation law for just this scenario. And those, there are penalties based on the premium. There are criminal sanctions. A carrier can report an employer such as this and have criminal charges brought. They can allege it under the fraud sections of the statute. They can allege it under this section, which says not having coverage and making misrepresentations are felonies. There are all kinds of remedies that can be availed of, and they're included within the workers' compensation statute, avoiding any need to go to 627.
But are any of these actually incompatible with the 642.409?
Well, incompatible means, first of all, none of them authorize the remedy that was granted here, avoiding a policy from the beginning. The 627.407 talks about denial of recovery, and again, that goes against the whole grain of workers' compensation legislation, is that it's for the benefit of the employee who's injured, and therefore the policy is in effect at the time of an injury, and if the carrier wanted to cancel it, they could have canceled it at any time. They could do audits. They have some obligation to at least figure out what it is exactly that they're trying to do.
Couldn't we construe the remedies, though, to be cumulative, that a carrier could void the policy under 627 and then seek penalties and indemnification from the employer under 440?
No, Your Honor. I would disagree with that because, again, going back to the fact that workers' compensation law is specific and a specific statute would trump one that is more general, 440.381, as indicated clearly by the court in Perkins, addresses such a situation, and therefore it's inappropriate to consider the general insurance code for that.
Is it your position we would have to overrule Perkins to rule against you?
Yes. And because Perkins addresses this situation and the judge clearly erred by failing to follow it. I would like to briefly, if I could, address the other point, because I know Appellee has submitted even notices of supplemental authority with regard to the claimant's employment status, and just point out that I would rest on our brief, but there was absolutely no evidence of a separate statewide business entity, as we alluded to earlier. We are well aware of this Court's standard of review of competent substantial evidence, and I would not be up here arguing that a factual finding supported by evidence should be overturned, because that is not appropriate. But in a case like this, where the judge has made a finding that is not a finding by accepting one person's testimony, but making an inference which is totally against any of the evidence, as Judge Wetherell and others have pointed out, that this has always been one business, it's Shamrock Services, at the time of this accident, and simply because additional types of duties were added during the policy does not preclude the coverage that is afforded to the employee. The employer then has to go get his remedies elsewhere. If there are no further questions right now, I would like to reserve the balance of the time for Mr. Zients in rebuttal. Thank you.
May it please the Court. My name is Arthur England. With me at council table is William Rogner, and we're here representing Zenith Insurance.
Mr. England, could you take that last point first? I believe the order suggests that there were two separate business entities, one of which only was insured.
And the last point raised was there's no competent evidence to support that. Yes, I'll be happy to take that one first, because, Judge Wetherell, starting with your first question, you had indicated that the first hurdle was something else. This is the first hurdle they have to overcome, because this Court has held repeatedly that if there is competent substantial evidence to support a JCC, it doesn't matter what other evidence is there, the order must be affirmed. And those were the cases she just cited that we filed by supplemental authority, particularly Cumberland Farms versus Manning. Amar Prakash conducted his business affairs as a sole proprietorship. He did register it as a fictitious name, Shamrock Services. That is just a fact that we don't know actually the date. But a sole proprietorship, Your Honors, can have multiple businesses. We made that point in our answer brief on pages 14 and 15. It was not denied by Mr. Bend, either in the reply brief or today, and it was admitted by the amicus, the Florida Justice Institute, to be the case. So a proprietorship, not an incorporation, not a partnership, proprietorship can do lots of things, and it can do them differently. So that brings us to the question, which is the heart of the first issue. Was there competent substantial evidence that Mr. Prakash was operating more than one business, as the JCC found as a fact? Yes, there was. First, lawn maintenance personnel were formally treated as employees from whom tax was withheld and who were given W-2 forms. You'll find that in the record at page 164 and at 1123-24. Painters, in contrast, were formally treated by Mr. Prakash as independent contractors on whom no taxes were paid, who signed contracts saying they were independent contractors, and who represented in those contracts that they would get their own workers' compensation insurance. Signed documents by Bend, Sigland, Lopresti, all of the people who were the identified painters, and you'll find that information in the record at 898, 1093, 1878, and 1945. But that wasn't all. Mr. Prakash testified in his deposition that he never intended to have painters covered by the Zenith policy. That's on record in page 1280. The record establishes that both Prakash and Bend always treated Bend as not subject to the Zenith policy or the lawn maintenance business that was being separately operated.
Now, was there an audit at some point?
There was.
Tell us about that.
It was because Mr. Prakash failed to respond to, at the end of the first year, an audit request. The formal audit was that they imposed Zenith imposed a 25% surtax because he had understated payroll. Someone went out and asked him, and he said, all my people are lawn maintenance people. He even lied and said Mr. Lopresti was lawn maintenance when Lopresti testified when he got to trial and through deposition. He had only done painting. He had never done lawn service.
So was Lopresti covered under the policy? Or how did that work?
No, he was an independent contractor. We're still on the issue of more than one business. These were facts that were before the judge of compensation.
Right, but he told the carrier that he was a lawn maintenance man.
No. Prakash lied to the audit personnel who went out and said, oh, no, Lopresti is a lawn maintenance person. And they added.
If that had been true, then he would have been covered.
He would have been covered under the, Lopresti wasn't injured. If he had been injured doing lawn maintenance work, he sure would have been covered. He would not have been covered if he was in the painting arm of the sole proprietorship, which the facts support, any more than Bend or Siglin would be. They were operating under a separate set of facts in a separate business, performing services for which Zenith had never agreed to issue a policy, either in terms of geographical scope, activity, the nature of the business, and other businesses using subcontractors and independent contractors. So those were the facts, but there was one other. I'm sorry.
What do we make of the certificate of insurance form that was issued by the insurance agent in August of 2007 in which Shamrock's operations were reported as lawn service, painting, home repair, virtually a handyman service?
You make nothing of that because it identified two insurance companies. The second was North Point. North Point was a general liability carrier. We don't know. There's no evidence as to what North Point insurance company. You cannot attribute the fact that it happened also to have Zenith's name on it, issued by an insurance company so that someone had a certificate to show somebody. You cannot attribute that to an acknowledgement, either by Zenith, because they didn't write it, or even Prakash, that the lawn maintenance business was what Zenith policy insured. It's meaningless. It's a ridiculous point to say that I have a certificate in my policy with 4 insurance companies' name on it, and that all of them represent every business that I have done or doing. I want to go back to the last factual point, 2 factual points about the separate business, because, Your Honors, this is dispositive of the case. You don't have to go any farther. If you find that the JCC's finding of separate business entities was supported by competent evidence, you can stop there and not deal with all the perhaps difficult questions. So the last 2 points.
Before you get to that, let me ask you this. I had trouble reconciling what the JCC orally found, where he said that Shamrock Paint Service didn't exist, and it should have, with what he found in his written order that there were these 2 separate entities.
I think he was, excuse me, Your Honor, I think he was talking about the incorporation which took place, which brings me actually to the other point, one of 2 that I was going to make
Before
about.
you get there, help me reconcile also
Okay.
the idea that, if I think I understand your argument, is Mr. Prakash misrepresented nothing to the insurance company. He said that I have a lawn service business that I want you to insure. What he didn't represent was anything about a painting company, which he didn't want him to insure. How do you reconcile that with the findings the judge made, which were he had this business that did all this stuff, and he didn't tell the insurance company he was doing all this stuff?
When the Zenith policy was issued, he was only in a lawn maintenance business with a few employees, all of whom were employees. He very shortly after that, and he had been advertising for but had no employees, entered into an independent contractor relationship with people for commercial painting.
So
Mr.
why
Prakash,
then should there be any voiding ab initio of a policy if no misrepresentations were made?
Mr. Prakash represented in that affidavit that he would update the insurance company with any changes, any new businesses. He never did, and in fact, in his deposition, he testified that he swore that he had never given additional information.
All right, so you can see Judge Weatherall's point that there was no misrepresentation originally. It was just a failure to keep the insurance carrier apprised.
That is probably a more accurate recitation of the fraud. Not so much fraud on the first day, but it was within a month that he had taken on other businesses. And when he went in, he got this insurance agency to put it under the lawn maintenance code.
I'm concerned a little bit about the implications of this argument. That say we have a grocery store that employs 50,000 people in the state of Florida. They obtain a workers' compensation policy to cover their grocery business. And then one day, two of their employees go construct a structure to house Christmas trees in during the holidays, and someone's injured. Is that then a separate business? And then do we void a policy that's been in place for 10 years that covers thousands of employees?
Your Honor, I know Mr. Ben's counsel would like you to worry about the big what-ifs and those situations. But that's not the situation here, and this case doesn't create precedent. This case is very fact-specific. Mr. Ben was complicit in the problem that's created by his not being paid under the Zenith policy. He knew about workers' compensation, having both had it and been employed with an exemption by his father, and always treated himself as an independent contractor. That's in the JCC's finding of fact on page 5. He exempted himself from workers' comp by having a policy when he was hired by Mr. Prakash, and let his policy lapse.
Let me ask your
knowingly.
Let me ask your views on this hypothetical. Suppose that that a lawn maintenance person had been injured while the policy was enforced and was receiving medical care and indemnity benefits from Zenith.
It would be perfectly appropriate for that person to do that. This policy was invalidated.
And then you get to this case.
Sorry.
And the JCC declares the policy void ab initio, or as we now understand, ab date of first failure to update.
With respect to commercial painting which was the only service performed for this proprietor, the only business being performed by Mr. Ben at the time of his injury.
Let me take Judge Benton's hypothetical and change it a little bit. Say you have a lawn maintenance person who, in the lawn maintenance business, that's what he said he was doing, but he represented on his application he was only doing it within 60 miles. Turns out they got a contract the day after he signed up, 61 miles away, 100 miles away, whatever it is. So you have a lawn maintenance individual in the lawn maintenance business gets in this same accident on his way to a job more than 60 miles away. Policy voidable ab initio?
I can't tell you the answer to that, but I can tell you that had the facts been represented accurately at the outset, and this was, again, an updated fact that was not changed, the policy, at least at the outset, would never have been issued. I have serious doubts that Zenith, in that situation, would have said, we do not cover lawn maintenance people operating 61 miles outside. That isn't this case. This case is about outright lies by Mr. Prakash, what he was doing repeatedly. It's by outright representations by Mr. Ben that he was an independent contractor. He signed in bold, underlined letters that I am an independent contractor and agreed to get my own workers' comp insurance. They can't cover that up with statutory employee status under the statute because that only applies to the construction industry. That doesn't carry over to lawn maintenance.
It doesn't apply to truck drivers?
It applies to, in any construction, it's a particular statute on construction industries. The commercial painting, including driving to the site, was covered by that. But that doesn't bring him under the business activity of lawn maintenance. It protects him if there had been insurance. If he had bought it or maintained his policy as he said he did, he would be covered. You know, there are all kinds of people who don't get covered by workers' compensation for any number of reasons. And while it is the state's policy, they have never instituted, for example, a fund like other states, for example, Arizona have, which compensate people who don't have workers' comp. Florida hasn't done that. It sometimes happens. But in this case, it's real easy because Mr. Bend put himself in the position in which he found himself. I must turn quickly to the issue of whether there was a legitimate reason for an application of Section 627.409 as opposed to the workers' comp provision 440.381. There's no question.
Before you do that, if I may, let me ask you if you agree with opposing counsel that to go your way, we would have to overrule Perkins.
Absolutely not. I'll start with Perkins. Perkins is a very fact-specific case where it was established on the record that there was a knowing misrepresentation to reduce premiums, treating someone as an employee who had been an owner, and the facts were to the contrary. So what happened in the Perkins case? They said the Florida legislature in 440.381 has made exactly this case applicable for this exact remedy. There was a specificity to that process that is unmatched. And while they keep saying that workers' comp is a creature of statute, I call your attention to the language of the statute, which they seem to ignore. It is a narrow provision, 443.81(6)(a), which deals with fraudulent misrepresentations for premium avoidance, and also a misrepresentation of duties of an employee so as to avoid proper classification of premium calculation. In other words, it's premium avoidance. There's no evidence in this record, none, that Mr. Prakash was avoiding premiums when he went and got his only business, lawn maintenance, workers' compensation insurance. They would have you believe that that's inferable or that can be assumed. That's not true, Your Honors. They took Mr. Prakash's deposition twice, never asked, never raised the issue, did you do this to avoid premiums? They knew from the declaratory proceeding and the pleadings in this case that Zenith was always arguing this statute and Perkins applied.
That's not the right time to look at under your view, if I understand it.
I'm sorry.
In other words, there was no misrepresentation, if I understood you correctly.
No, there was not. No, my point is they have not either made it an issue below, therefore it's not preserved, or there's no evidence of it. None whatsoever. Now, I don't know how
All right, but you're not saying that the failure to on a quarterly basis or whatever it is, update the carrier, you're not saying that did not result in Mr. Prakash having to pay fewer premiums?
No, I don't understand your question. I'm not saying that.
If Mr. Prakash had told the carrier, Shamrock Services is now painting houses as well as doing lawn services and cleaning parking lots and so forth, would that not have resulted in higher premiums?
No, because they don't write the policy for premiums under $25,000 for that business. That's undisputed testimony of the vice president of the Florida division, acknowledged by the JCC as a finding of fact. Zenith does not write insurance for commercial painting for this level of premium. Period. End of case. So the answer to your question is they would have canceled the policy if you had told them the truth at that point.
Well, allow me to pose this question to you, because 443.81, and again, in addition to the penalty provision, has an indemnification provision and also has criminal penalties against the employer who misreports. Why shouldn't those remedies be the exclusive remedies for an employer who fails to report or seeks to provide misleading information to a carrier for the purpose of obtaining workers' compensation coverage?
It's because the last phrase you used is the one that Mr. Ben's counsel will use, that's inaccurate. It's not for the purpose of obtaining a workers' compensation coverage. It is for the purpose of avoiding premium cost in an application for insurance. This policy is very specific. I take their quote seriously.
But how does that statute read?
How does it read? If an employer understates or conceals payroll, or misrepresents or conceals employees' duties so as to avoid proper classification for premium calculation, or misrepresents or concealed information pertinent to the computation and application of experience rating modification factor, the employer shall pay 10 times.
10 times what?
10 times the difference between two premiums that would have been the right premium versus the one that was charged.
All right, 10 times the difference between the premium he paid, here, the zero,
Yeah.
and the premium he would have had to pay if he had disclosed to an insurance company who sells this type of insurance.
Not to an insurance company. If you disclose it to Zenith, there wouldn't be a policy. They don't write it. The record is perfect clear that they would not insure this risk. And that, Your Honor, that's the heart.
Isn't that the case, though, that this statute is directed at? I mean, certain carriers aren't going to provide coverage, had they not been provided with a misrepresentation. So if the misrepresentation is I have 10 employees and the carrier only wanted to insure 5, or there could be a series of misrepresentations, and the carrier can always say, I wouldn't have insured this risk had I known about the misrepresentation.
Your Honor, we can't guess why this statute was enacted. We only know what it says. They keep saying that workers' comp is a creature of statute. The statute says it's for premium avoidance. 3 different ways it says it, but premium avoidance. The fraud for which the JCC found this policy invalid was the nature of activity, the types of businesses, subcontractors and independent contractors, and geographical distance. None of that has to do with premium avoidance. Our one overriding point in this, which I'm sorry they just haven't addressed, is there is a statute that deals with fraudulent policies. It's 627.409.
And where in that statute does it, in the text or even by inference, suggest that a JCC or even a circuit court judge can void a policy?
It says it right on its face, and it was held by this court in Kaiser and in any series of cases that we cited. DeGuerra, a summary judgment. Fraud in the application process, answering questions mistakenly, allows a cancellation of the policy. You've never heard counsel say, and you haven't read anything they've said, that 627.409 is not applicable to every single class of insurance. It's in the insurance code. Even, by the way, the Division of Workers' Compensation doesn't say that.
Before you sit down, with the indulgence of the Chief here.
Oh, I'm sorry.
I guess my question is the one I asked initially. Where in Chapter 440 is the JCC given the authority? Put aside the question of can a circuit judge do it. What in 440 gives the JCC the authority to invalidate ab initio a policy?
May I respond to the question?
Very briefly.
Section 440.33, Section 440.42, and the decisions of the Florida Supreme Court in Fireman's Fund versus Rich, International Piling versus American National, this Court's decision in Morgan Yacht versus Edwards, and the decisions of the courts of Florida, which repeatedly said that a JCC has authority to interpret contracts and that no court can rewrite a policy to include insurance which could not have been written or was not written to create insurance, I guess is the way the courts have put it. But you have those provisions about a JCC can do anything conformable to law which is necessary to the exercise of his duties, and Mr. Bend went right into the JCC and said, you have the by stipulation, you have the jurisdiction to deal with the issue of a fraudulent policy. Let's go at it. Thank you, Your Honor.
All right, thank you. Madam Clerk, will you add another 2 minutes, 30 seconds to rebuttal time?
Thank you, Judge. Mark Science on behalf of the appellant Robert Bend. Let me start with Mr. England's last comment regarding the parties stipulating to jurisdiction. I think we all know that you can't stipulate the subject matter jurisdiction, and we're going to leave it at that. Regardless of what the parties did, this Court has to determine whether or not the compensation judge has the authority to void a policy under the insurance code. I would point out that 44011, under the exclusive remedy, says that the insurance code provisions regarding bad faith in policies doesn't apply to workers' comp. The workers' comp is the exclusive remedy, and the insurance code is not a remedy under Chapter 440 for any purpose. I think you hit it on the head when you said, where is the authority in Chapter 440 for voiding a policy? It's not there. The compensation judge may, if the question arises, may interpret a policy, the language in it, but you don't even have the policy. It's not in the paperwork. It wasn't submitted to the judge. We don't know what it says. We don't know whether it has a clause that says this policy is incontestable after a year, as some insurance policies do. We don't know what's in that policy because the appellees chose not to present the judge with the document that they asked them to void ab initio. We've cited cases in our briefs, both our initial brief and reply brief, that talks about the language in the policies. And the language in the policies most often talks about correcting the premium, charging for what you actually used as opposed to what your application said. Judge Rowe, you pointed out something very interesting, and Ms. Wagner and I have talked about it all the time, and that is, from day to day, the nature of a business may change. Businesses merge. Businesses buy other businesses. Businesses buy equipment, as Mr. Prakash did, to do parking lot sweeping. In lawn maintenance, he may have bought some piece of equipment, and Zenith may come in and say, well, if we had known at the time you entered into that policy and filled out that application that you were going to buy a weed trimmer of this type, which cuts people's toes off, we would have never written that policy. But they don't get the chance to say that. They have the right to investigate. They have the right to audit. They have the right to go out and physically look at the operations. And they have the right to then cancel if the operations are not within their underwriting guidelines. But they don't have the right to ask for the policy to be voided ab initio. And that's because these policies cover multitudes of people who, as Judge Benton pointed out, may very well be receiving medical care and indemnity benefits at the time the Bend Prakash problem arises, and then all of a sudden Zenith will come in and tell them, well, sorry, we've had this policy voided ab initio, so you're no longer entitled to the next visit to your doctor, or no longer entitled to that next compensation check, because even though you had nothing to do with this dispute, your coverage is gone. That's not the public policy associated with workers' compensation.
Or now he's arguing that we don't even get to these issues because it's an entirely separate business.
Nonsense. Mr. Prakash was an independent person. His name appeared on the application as the person seeking insurance, not Shamrock Services, not Shamrock Painting, not Shamrock Lawn Care, not Shamrock anything. Amar Prakash. Whatever he did in terms of his business, when he went out and solicited customers, if they wanted him to put a new roof on the house, Zenith may say we don't cover roofers. But they would have assumed the coverage merely because they issued a policy to Mr. Prakash and because he went out and did it. What if he decided he wanted to start a skydiving business? Wouldn't matter. It absolutely wouldn't matter. And that's the public policy.
What is your strongest case for that?
Well, there are any number of cases where employees are sent on special errands by their employers. Please, take this stick of dynamite out to the farm and blow up a tree stump. Well, the employer's a real estate company. They don't blow up tree stumps. But when you give that employee a special errand, he's covered. The workers' compensation law and the cases say that the workers' compensation carrier stands in the shoes of the employer, and they are to pay whatever the employer says or engages in terms of his operations and whatever liability he incurs on behalf of the insurance company. An employer can even agree to pay greater benefits than the workers' compensation law provides, and the carrier has to pay them. So this is a system in which the protection of the workers' compensation law is not so much for the employee or the employer, it's for all the taxpayers who are now footing the bill for Mr. Bend. When you enter into that contract, there's only one way that contract, the workers' comp, ends, and that is it's canceled by giving 30 days' notice to both the insured and to the Division of Workers' Compensation.
Well, Mr. England said he wasn't even an employee.
Well, I think we've gotten past that because he's a statutory employee as part of the statute which requires construction-type work, including painting, to automatically be covered. And no matter what he promised to do in his contract, and no matter what Mr. Prakash tried to get him to do, and you can all see that Prakash's intent was to avoid premiums on independent contractors, even though they should have been covered. That's where the intent to cheat Zenith out of premiums. And what did Zenith do when they discovered that they were being cheated out of premiums and discovered that Mr. Prakash wasn't giving them information? They said, we'll cover whatever you have. Just pay us 25% more than we estimated your premium to be. And they accepted it.
Is there evidence that they learned of the painting before they asked for that 25%?
I don't think before, but Prakash did testify. He told the agent that he was in the painting business and that that information was supposed to be supplied to Zenith. But other than that, I don't know the answer to your question. But again, I don't think it matters. Workers' comp premiums, you can see from the application and from the other insurance documents in the record, are not calculated up front. They're estimated.
Let me ask you this. Forgive me if this is a stupid question, but using Judge Rowe's grocery example, you've got a grocery company who hires someone to do construction work, painting work, we'll say, as an independent contractor. That independent contractor does not have his own coverage. He, though, by statute, because he's doing construction-related work, becomes a statutory employee of the grocery store. Is that how that statute works?
Yes. Okay. And as such, he's entitled to the coverage of the workers' compensation law, and the remedy for the employer changing the nature of his business, so to speak, is to collect the correct premium. And if the employer, as in this case, didn't inform the carrier of the nature of the business, the remedy is to charge 10 times the difference between what he should have paid in terms of premium and what he did pay. So all of the remedies are in the compensation statute.
So my example is what we have in this case. We have a lawn service company that was insured. Let's assume for the sake of argument there were two.
And not fraudulently insured, but insured.
Correct. And he then engaged an independent contractor who had no coverage to do work.
Construction work.
And so he became a statutory employee of the lawn service company.
And the lawn service insurer, whether they intended to cover painting or underwrote painting, were obligated to pay the claims that the employer was supposed to pay, as opposed to having those claims shifted to the public at large. And that's the way our workers' compensation system is, and that's why Ms. Wagner indicated to you that she did not believe even a circuit court judge could void a workers' comp policy ab initio. That would violate our public policy, and it would also create, as she said, chaos, because no one who was receiving workers' compensation could be assured that they would get that next check if somebody in another case went out and proved that the employer had lied on their initial application, and some judge, whether it was circuit or judge of compensation claims, voided the policy ab initio.
What do you say to the argument that Zenith would not have written insurance here if it had known the facts as they eventually came to be?
Actually, Mr. England admitted that they would have written the insurance because there was no fraud in the initial application. They would have written the lawn service. If Mr. Prakash the next day went out and became a painting contractor, He had the obligation to tell them he had additional employees or independent contractors, and the nature of his business had changed. But if he didn't tell them, the remedy is not to void the policy. The remedy is to charge the right premium and cancel the insurance if you don't want to write
Now,
it.
I'm going to, this goes to the question of what the right premium is. He says there is no right premium. They would not have written the insurance.
Oh, there is a right premium because every occupation is listed in the classifications of occupations, and it's so many cents per dollar of payroll. That's the right premium. There's no problem with determining what it
So you're
is.
saying it's not, this is not a reference to any particular insurer or policy?
I think that's correct. This is the nature of the workers' compensation system, that you pay the premium retroactively for the operations and employees you have. If I have 10 employees today and they figure my estimated premium is $1,000, and tomorrow I go out and hire 500 people to work for me, when that's discovered in an audit, they go back and charge the correct premium. It's not a determination going forward. It's a retroactive determination, and the policy says they can go back 3 years.
But Mr. England says that even if you had given us all that money, we wouldn't have written this policy because we're just not in that business.
And once again, he also admitted that they would have written the policy as it started out. They would not have continued to write it, maybe, that's not in the record, if they learned later on that Mr. Prakash had changed his operations. But during that period of time, until they learned that, either by their own audit, by his admission, or by some other means, then the employees are covered regardless of whether or not they would have written the policy had they known that he was going to add painting. Thank you very much. We ask for you to reverse.
All right, thank you. Thank you both.